Indeed. So welcome to everybody who is listening or hearing in one way or another. Nicholas Le Poidevin, King's Counsel. His patent, I suppose, shows his excellence in his profession. In the Inn, he is a bencher and has been for many years. He's also chairman of the Library Committee, but he's also a serious legal historian. He has just finished being president of the Selden Society, which is, I suppose, the English-speaking world's premier society of legal historians. And he has a book in their annual series on the way. It's fair to say that, like many books in that annual series, it's a book that's been on the way for quite a while, but I was glad to see that there is a publication date now announced. Yes, I think, didn't I see that, or did it just say forthcoming? Oh, it's forthcoming. It's forthcoming. That's right. It's on the way. It's on the way. I'm sorry if that caused a shock just at the moment. Anyway, he's spoken to the Black Book Society previously on the building, on the early buildings of the Inn, a talk which revealed much that was, if not completely unknown, at any rate new, I think, to all his listeners. This time, during this year of celebrations of 600th anniversaries of the Inn, we're not quite sure what it is the 600th anniversary of, but it's certainly the 100th anniversary of the date selected for the 500th anniversary. And we've been having a number of lectures sort of looking at various aspects of the Inn. But Nick's going to look tonight at what the law was about in 1422. I mean, I think we're all sort of vaguely conscious that law even yesterday was different from what it is today. But I think we shall find that the concerns of our predecessors in the Inn of 600 years ago were completely different from anything that occurs to us. So, Nick.
Is this live? Can you tell? No? It is, okay. Thank you very much for coming. Those of you who have. This was postponed from November because of a rail strike, which didn't take place and is now going ahead in December against the background of a rail strike which is taking place. So well done. Thank you for those online who weren't able to come in. The law in 1422, it is a big subject. I would like to have begun with a snapshot of early 15th century England in 3 minutes, but time is limited, and so, to be honest, is my competence. But I do want to see if I can brush away some cobwebs, because the Middle Ages are quite often thought of, perhaps not consciously thought of, but unconsciously, semi-consciously thought of, as a block of time in which nothing much changed. So at the top, you've got the king. This is the caricature version of the Middle Ages. A sort of Brian Blessed character, booming at everybody and eating too much. This one, if you look closely, goes in apparently for Cornish pasties and grapes, which is a combination I've never tried. Below him, there are knights clanking around the countryside in full armor, either rescuing maidens or harrying the peasantry according to taste. Then the peasantry, if you believe the films, spending their time trudging through mud, living in houses built of mud, if apparently wearing clothes woven of mud. Nobody can read and write except the clergy. The church is a sort of army of occupation, greedy, oppressive, and bigoted. Now, starting with the block of time idea, clearly things change between, say, 1066 and 1422. An equivalent period of backwards from our own time would be back to 1666 and the Great Fire. Nobody would imagine that 1666 was more or less the same as nowadays. In 1422, the king is not like Brian Blessed. In Michaelmas 1422, when the Black Books start, which I think is what we're celebrating, this is what the king looked like, and I'm sorry it's a rotten. In fact, it looks even worse from here. It's not too bad over there. The right-hand one shows the close-up of Henry VI, who is 9 months old. That's the best I can do. There are knights, but knighthood is a rank in society. with legal and administrative duties which not everybody fancies. And so men sometimes have to have their arms twisted to accept the accolade. If they fight, they mostly don't do it here, but they go, fortunately for us, they do it abroad. Peasants, an enormous group, it's an agricultural society ranging from the half-starved labourer to the prosperous farmer. There's a large literate lay class of administrators and, of course, lawyers. Who else would you find in Lincoln's Inn in 1422? And there are substantial numbers of merchants who, again, need literacy to do their business. The church doesn't stand outside society, but is integrated into it. The clergy, like the laity, range from the very rich to the very poor. And there's a vigorous intellectual life in the universities. So that I wanted just to dispel the sort of quaint idea of the Middle Ages, the sort of, if you put in medieval times into Google, you get a king like that and knights and so forth. It's not really like that. So it's a disparate society and a litigious one. Early 15th century England is not short of courts. Starting at the bottom, at the level of the manor, there's a manorial court presided by the steward of the lord of the manor and attended by the tenants. It adjudicates disputes at this local level, say trespass and debt, but it also provides a forum for land transactions, the transfer of copyholds, those who are unfree, the villains, having to use the Lord's Court for this purpose. And incidentally, that is still done in Guernsey. You have to turn up in the royal court to effect a transfer of land. And the manorial court also regulates the agricultural practices of the manor with penalties for the uncooperative. This is a manorial court roll, not quite from 1422, but from 1435 in a modern edition. So you can see, it's a bit difficult for me over here, but you can see at the top a couple of actions of debt and another one of trespass, then and a further one of debt, I think. Then in the middle, you've got penalties for breach of agricultural discipline, and at the bottom, a transaction in land done as it was until 1925 by surrendering the land to the lord of the manor, who then re-granted it to the purchaser or donee. Most people outside towns will be familiar with a manorial court. This court, the manorial court, not just the Wakefield one, but generally, preserves in miniature a much older idea of a court, which is still in use when we talk about the court of Edward I or the court of Elizabeth, or nowadays in a small way, the court of St. James's. That's a court with courtiers, attendant on the king or queen, comprising the great men of the kingdom. Men, I'm afraid it always is. Originally, the tenants-in-chief of the king, and also loads of hangers-on hoping to do themselves a bit of good. So a court in this wide sense settles disputes amongst the great men as part of the ordinary business of government. But they're primarily there to assist the king in government. And it's some time before a separate judicial function with separate officers sloughs off from the parent body, though here in England, this process, the first stage of that process, has taken place more than 2 centuries before 1422, the early 13th century. You see distinct courts. It generated 2 royal courts rather than 1 in this more modern sense, for reasons which have something to do with the minority of Henry III. There's a King's Bench for cases with a particular royal interest, including what we will call crime, and the Common Bench or Common Pleas for ordinary disputes, which by 1422 is much the more important of the 2. And the Common Bench plea rolls for a given term are perhaps, I don't know, 6, 7 times the size of the King's Bench. Even then, the King's Courts aren't for everybody, and it's only after the Black Death, so after the middle of the 14th century, that most civil claims can be brought by anybody, can be brought in one of the benches. This is the Common Bench in around 1450 or so, so a little after our time. This is one of 4 miniatures which have been snipped out of a book of abridgments, of sort of case summaries, and are owned by the Middle Temple, and you can go and look at them there. The flyer for this talk was actually the King's Bench, but it looks quite similar. But this is the common bench. I mentioned the process of a judicial function sloughing off from the ordinary business of government. This is happening again in 1422 in a different way. Aggrieved persons will petition the King's Council or the Chancellor, his chief minister, for redress when ordinary justice, so they say, is not available or not adequate. And extraordinary interventions gradually become routine, and routine involves recognizable rules. And this is the origin of the Court of Chancery. But in 1422, there is no body of equity or anything like it. There is no set of rules or principles which can be identified. So law reporters are not really interested in what goes on in front of the Chancellor. In another generation or so, by the middle of the century, that ceased to be true. And common lawyers are taking an interest in what goes on in Chancery. There are some recognized rules, and Chancery in particular is regularly enforcing uses, which are the precursors of trusts. So manorial courts, the 2 benches at the top, between the 2, you've got a variety of other courts. In towns, there'll typically be a town court. That will be an enlarged version of the manorial court, where the town is in the hands of a feudal lord. But if the townspeople have managed to secure some form of self-government by charter, the court will be in the hands of the mayor and burgesses. Bigger towns and cities will have some more complicated arrangement. The City of London, in particular, has a number of courts. In the counties, there is a sheriff, sometimes 2, but usually 1, who is the principal royal officer in the shire and has a variety of governmental functions. At intervals, he holds a county court, which has nothing to do with the modern county court, which was created by statute in 1846. And he also holds a 100 court, the 100 being a subdivision of the county, most counties anyway. But both those courts by 1422 are in decline. There are a number of jurisdictions in addition to the separate courts, which are created by a royal commission addressed to some of the judges of the 2 benches, or comparable senior lawyers and other prominent individuals. And these commissioners ride circuit twice a year. There are several circuits, as indeed there are now, except circuit is a bit of a misnomer nowadays. They ride out in Lent and in the summer, in the intervals between the 4 legal terms of the year, separate commissioners for each of several circuits. And this formally came to an end with the Courts Act in 1971. There's a commission of jail delivery for clearing the jails and releasing or hanging the inmates. This actually is a French illumination, but I can't imagine English hangings were very different. So there's a jail delivery, what it sounds like. There's a commission of assize for certain claims to land, and a commission of nisi prius, which means dealing with taking verdicts on cases begun in Westminster in the benches. Those commissions are held together, and the judges riding circuit deal with those cases together. Separately, there's a commission appointing justices of the peace, issued to local dignitaries reinforced by professional lawyers, and they can try felonies. The jurisdiction of the benches and those conferred by commission are all emanations of royal authority, but the Crown can grant away, and does so, can grant away jurisdictions to private persons in the form of what are called liberties or franchises, which can also be claimed by prescription, and in fact more often than not are claimed by prescription. And some of these are extremely sweeping. lords of franchises like to hang on to their right, their jurisdiction. Maybe the income is worth having, though I think that's often exaggerated, but it's part of the job, part of the prestige, my court, my tenants and so forth. They keep attorneys in the benches to watch out for actions started there, which ought to belong to the franchises. And if that happens, they can claim a transfer. So, for example, the Abbot of Glastonbury had a very wide franchise, have an attorney in the common bench who would pop up and say, oi, that case ought to be transferred, and the common bench will transfer it. So the masses of courts of those kinds, all administering some version of the common law, the benches have different forms of supervisory control and impose some uniformity, though local custom is respected. But even if you assemble all the claims and remedies which were available in those courts, you wouldn't have a full picture of the legal system, because there's a completely different set of courts throughout the country, the courts of the church, court Christian. These are not the specialist and, if Mark will forgive me, slightly obscure tribunals of today. They administer the canon law of Christian Europe, and they impinge on everyday life. Here is, it's a bit of an anachronism. This is the only picture I could find of a consistory court, and you can see it's 200 years late, but there it is in Chester Cathedral. The jurisdiction of these courts are not just a matter of church affairs as we would now understand it. The law of marriage and divorce of a kind, and the law of legitimacy are mostly the province of the church courts. The same is true largely, not quite entirely, of the law of wills, perhaps more properly testaments, and the administration of estates. Both those jurisdictions, marriage and divorce and wills and estates, were handed over to secular courts in 1857. More surprisingly, perhaps, the church courts also have, at this time, a flourishing jurisdiction over contracts and also defamation, which was not actionable as such at the common law. But I want to concentrate on the common law courts, and particularly the central courts, the two benches, which sit in Westminster Hall, though the King's Bench has been peripatetic, because at one time it would follow the King, and occasionally still is. The last occasion seems to have been in 1414. And I want to concentrate on them because the sources are better than for any others, and partly because that's where, in those courts, is where the common law was made. Now, I want to start with procedure rather than substantive law, though the distinction is anachronistic, and with civil law rather than criminal law, though the distinction is again partly anachronistic. Nearly all civil actions are begun by writ. It's an original writ because it originates legal proceedings. This was so, that is, the writ was the primary instrument for starting proceedings until 1999, when Lord Wolfe decided that everything had to be called something else. The original writ is a royal command on a slip of parchment issued out of the Chancery, which is the King's Secretariat, in practice by a Chancery clerk who will write one out for a fee if given the basic details required for the claim. There is one. I'm not sure who those fingers are, but it gives you an idea, quite a small slip of parchment. It's not addressed to the defendant, but to the sheriff, the King's executive office in the counties. In substance, it tells us the sheriff to summon the defendant to appear in one or other of the benches on a given day to answer the plaintiff's claim. The writ's conveyed to the relevant sheriff by someone on behalf of the plaintiff, that's from Westminster to the county, and the sheriff, or rather some officer of the sheriff, then acts on it. That's what Chaucer's summoner did. The operation of summoning the defendant can be a rather fraught one, and there are cases in which the defendant forces the summoner to eat the writ. The sheriff then returns the writ, if not eaten, not to the Chancery, which issued it, but to the bench mentioned in it in time for the return day, also mentioned in it. And the sheriff writes on, or his officer, in all probability, writes on the back what he's done with it. And the statement is the return. And it says he's been summoned, or he hasn't been found, possibly he's too ill to travel, or the writ arrived too late. The writ is filed in the bench, which means attached to a thong, by the filing clerk for the relevant county. And so the plaintiff or his attorney can easily check whether what has happened. If the defendant is duly summoned but fails to appear, then at the request of the plaintiff, a further writ is issued, this time out of the Common Bench or King's Bench, and in the name of one of the Chief Justices. So it's a judicial writ, original writ from Chancery, judicial writ from one of the benches, but again directed to the sheriff, telling him to apply more pressure on the defendant to compel him to appear. This is the best I could do to get a one with the Treasurer's name on. You'll see in the translation, the plaintiff is John Crow, clerk. Jonathan is not a medieval name. And you can see top left above, just to the right of the word London, the name in the original. So if you have trouble getting hold of the defendant, then you can get a series of these writs of increasing stringency to compel appearance, ending, if need be, with one outlawing or directing the outlawry of the defendant. You don't get judgment by and large in default. And probably the reason is that there's already plenty of scope for monkey business, and a statement by the sheriff that the defendant had been served, but then he doesn't turn up, would not be a sufficient basis for assuming that that was really true and giving judgment against a defendant. So assume that the defendant does appear. Now the plaintiff has to state his case against him, and that's done in a count or declaration. A writ of debt, for example, just asserts that the defendant owes the plaintiff £10 or the like. The count is more detailed. The plaintiff says it's due on a loan or a sale or the rent under a lease. And formally, this is the first that the defendant knows of the ground on which he's said to be liable for the debt. The defendant may then ask for a day over, that is an adjournment. The JOUR is the day over. Otherwise, he's either got to admit the action or defend it by pleading to the count. And there can then be a replication from the plaintiff, rejoinder, surrejoinder, rebutter, surrebutter. Not sure there are any names after that. And we still plead nowadays, of course, though the rules are a bit different. And pleading is absolutely central to the development of the common law, and I want to come back to it in a moment. And the ultimate result is to identify a proposition of fact, for the most part, asserted on one side and denied on the other. And that's the issue, which simply means something emerging from something else, but it came to mean a dispute or a point of dispute because that's how it was used in a legal context. Then the issue has to be tried. The usual method is trial by jury, but there are a number of others, which I'll mention if there's time. If there's trial by jury, another judicial writ goes to the sheriff to summon a jury. That's the writ of venari facias. And the trial may take place in one of the benches, or more likely, because it's more convenient, before the judges on circuit at Nyside Priors. The jury then attends on the day fixed, and they will have been told what the issue is beforehand. The jury is not summoned to listen to evidence impartially, as it is now in a criminal court. It's summoned because it's already supposed to know the right answer, which it tells the court. And the transition to the modern jury seems to be a product of the 16th century, though legal representatives certainly attended trials in the 15th. And how the jury is supposed to have informed itself in advance of the trial is a bit of a mystery. It is, I think, absurd to imagine people tramping the county to interview potential witnesses. And what happened, in some cases at least, is that the parties got the juries together immediately before the trial, when they'd be assembling in the assize town anyway, to state their cases. And unless something like that happened, it's difficult to see how else the system could have worked. Evidence on that is in short supply because law reporters weren't much interested in trials. The interesting legal argument has already happened in the course of pleading. If the trial's in the bench, the court takes the verdict and immediately gives judgment on it. If it's on circuit, the clerk on circuit sends a record of the verdict back to the bench, and judgment's given when the next term starts. Broadly speaking, judgment after verdict is automatic. The law is not discussed after verdict. The primary forum for debating law is at the stage of pleading. So I want to return to pleading because of its importance. When the defendant pleads to the plaintiff's count, he's got a choice. He can plead the general issue, or he can put forward a special plea. Each action, say debt, debt in lieu, trespass, and so on, has got a standard general issue. In debt, it's he owes nothing. In debt in lieu, he does not detain the goods. In trespass, he's not guilty. That's in a civil case, remember. So those pleas are broadly equivalent to saying not liable. And now the plaintiff may be in the dark about the proper grounds of defense, but there's no provision for further information or particulars. The defendant can always plead the general issue if he wants to. And if he does, that's the end of the pleading. The parties have joined issue, and then it's a matter for trial. But there is an alternative to pleading the general issue, which is a special plea. Nowadays, of course, special pleading is misused to mean unconvincing excuses, but originally it meant a particularized plea. So suppose the real defense in an action of debt is that the plaintiff has given a release, or that the defendant was a minor at the time of the transaction. That can be pleaded instead of the general issue. A plaintiff can then retort with the replication, modern reply, and they can plead back and forth. But choosing between the general issue and a special plea matters because it's a rule, though it looks an odd one to us, that you can only plead one plea. You can plead you were a minor, or you can plead that you've got a release, but you can't do both. And the theory, which you have to infer because it's never stated, is that the court must be in a position, in general, to give judgment after the verdict for one side or the other without more ado. So the parties have to be committed to an issue on a single point of fact. The jury is not given a questionnaire, so you better plead your best case. In the distant past, pleading was done orally in court, though recorded by the clerks in Latin. Now, most of it takes in writing. I say now, in 1422, most of it takes place in writing. You either give the clerks a draft plea, or you ask the clerk to put your plea into proper shape and then record it on the court rolls. So masses of common form business is conducted out of sight of the judges, and huge quantities of these records have survived. But the court still supervises the process of pleading. So instead of doing it on paper or parchment, you can tentatively state a plea in open court if you're uncertain of its legal validity, or you know that it's going to be challenged. And then there can be an argument about it with the other side. You do it tentatively, because if you commit yourself to a plea, the other side may demur, effectively saying, so what? The other side can pin the whole case on the proposition that what you said is legally ineffective. And if the judges decide that the other side is right about that, then judgment is given against you without inquiry into the facts. But if you plead tentatively and a problem emerges with your plea, you may be able to improve it by adding a fact or two. Or if you see that the court is against you in the course of argument, you may abandon it and choose to plead something else. And that's what's going on in the slide of the common bench I put up earlier. Judges in red, the advocates have got that funny white coif at the front in their green and blue robes, and in the middle the clerks keeping a note of what's going on their rolls. But the primary business is all pleading on cases of some difficulty, eventually some issue is reached. And the time of the benches is mostly occupied in dealing with this. And so medieval law is a bit peculiar. This system doesn't give rise to many formal decisions on the law because the advocate won't usually persist in a plea if he can see that the court is leaning against him. But much debate is inconclusive, and the contemporary law reports are therefore reports of argument rather than reasoned decisions. And what they reveal is not binding decisions, therefore, but a professional consensus. Or maybe there is no consensus. A debate may be interesting precisely because the point is unsettled and arguable. So it's a feature of this system that legal argument takes place in the course of oral pleading before the actual facts are known. Law first, facts afterwards, by way of the verdict. So pleading has to be precise, and the legal rules developed are also precise. There isn't much room for a fudge or for discretion. This is a very brief example from Michaelmas 1422. This is a modern edition. When I say modern, I think 1933. The upper part is above where it says translation is the report. In fact, two reports, but one has been adapted as a head note by the editor. Because this is perhaps not a brilliant example, but I needed something short, and it's not brilliant because you can't see the argument. But the reporter thought it worth recording that non est factum, which we're still familiar with, could be pleaded when the contents of the deed, which in this case was a bond, had been misrepresented to the person who made it. So it wasn't just a matter of saying, I never sealed it. You're saying, well, I did, but it was misrepresented to me. And then below that, there is that's what the top part is what the reporter thought worth recording. The bottom part, translation of the record is what the clerks kept, and they kept a record of everything, whether it's of legal interest or not. So these reports, under the name the yearbooks, which is not contemporary, are the main source of the later medieval law. They're in French, law French, since French was the polite language of the upper classes in the 14th century, though oral argument in French is probably giving way to English about now. The yearbooks circulated around the profession in manuscript and were later printed in the 16th and 17th centuries, though the most recent edition for nearly all of them is that published in 1679 to 1680. We have to rely on those, which have never had modern editorial treatment. This one on the screen is one of the few that has. Mostly they can be, they're fairly telegraphic, but they can sometimes be quite vivid. And we can be pretty sure that we're reading more or less the actual words spoken some 600 years ago. So a few dicta there that I picked up, little bits of judicial wisdom. And you'll see, well, the first one you might be able to say nowadays, if you didn't mind having your head snapped off. The second one is curious. The third, Sergeant Rolfe seems to have been a particularly discourteous advocate. And the last one is a very sensitive intervention in an argument about legitimacy. So I've talked a lot about procedure without saying much about or anything much about the substantive law. What did people litigate about? Some of the topics look familiar, some don't. If we look at the personal actions, meaning actions essentially for damages as opposed to recovering things, mostly land, you've got trespass in its various forms, very recognizable now. Trespass to the person, which covers highway accidents as well as deliberate assaults, trespass to goods, and trespass to land. Detinue abolished in 1980 something, I think. It was brought when the defendant has got your goods. Replevin, a new word for many people, I suspect, but abolished only in 2014, deals with challenges to distress for rent and is very common. There are various other personal actions, but the commonest of all these is debt. And the common bench is in quite large part a debt collection agency. The largest disputes by value, though not in number, are disputes about rights in land. And the land is protected by the real actions in which you can actually recover the land and not just damages. I can't do a complete survey of the substantive law, but I want to bring a touch on a topic that brings in the canon law as well as the common law, and that's women in the law. This is a topic replete with myth. It is quite common, even amongst some professional historians, to believe that medieval women were chattels. Here are some chattels. So whatever the legal proposition means, it is in fact nonsense as a piece of law. Nobody could, for example, could imagine that the wife of Bath was somebody's chattel. And other contemporaries, as Julian of Norwich, the mystic who wrote Revelations of Divine Love, who dies around this time, and her contemporary Marjorie Kemp of what was then Bishop's Lynn, now King's Lynn, also a mystic and a pain in the neck, who dumps her husband and travels to the Holy Land on pilgrimage on her own. Although women aren't chattels, they're not the equals of men. In practice, they're not appointed to public office of any kind. They don't serve on juries. With one exception, there's a jury of matrons, which can be empaneled to decide whether a woman convicted of felony is pregnant, because if she is, she can't be hanged until she's given birth. This procedure, I only found out in the last few days, was abolished in 1931. Women don't become lawyers or physicians, though in towns they may well engage in trade. And women, of course, are not ordained in the church, though there are around 140 nunneries, some of them rich with well-born women at their head. This slide shows a prioress, Amesbury, Maria Gore. There's her brass on the left, and on the right, she took office just about now, 1420, 1422, that sort of time. She died in 1436, but soon after she took office, she's suing in the Exchequer against the king for restoration of the temporalities which the king had collared during the vacancy. You can see her name, with a bit of luck anyway, just under the word wilts, near the top and on the right on the left of the record. In private law, they're treated rather better, but the great difference is not between women and men, but between married women and others, between a femme covert and a femme sole. And unmarried women can own chattels, can acquire and transfer land, can incur debts or become entitled to them. She can sue and be sued, in all cases, like a man. Here is a letter from the Stonor Letters and Papers to by a prosperous woman, a widow, telling her feoffees, trustees, what she wants done with her land that they're holding for her. So women perfectly capable of writing this sort of letter, and it's legally effective. It's also common for a husband to appoint his wife as executrix, though usually with others too. In the case of married women, things are rather different. Her legal personality is largely subsumed in her husband's. She can't sue without him, not even for an injury to herself. Her personal chattels pass to him outright on marriage, and he's entitled to sell them or give them away. And that, in fact, remains true until the Married Women's Property Acts of the second half of the 19th century. And if he dies and she survives and there's some chattels left over, still they go to his executors and not to the widow. under local custom, she may have a right to legitimate a claim to some part of the personalty, but that's local custom. Rules for land are more favorable to her and quite different. It doesn't simply pass the husband. On marriage, the husband becomes seized, more or less possessed of the land, and he can take the profits. And but if he alienates it and she survives him, she can recover it back by a special action for the purpose. As a widow, again, if she survives him, she can also claim dower in his lands, that is a life interest in a third of them. Actions for dower are very common, quite often brought by the wife jointly with husband number 2. If she dies first, her land goes to her heirs, not to the husband or to his heirs, except that if, but only if, a child was born of the marriage, then whether it's survived or not, he takes a life interest in the whole of her lands by the courtesy of England. Courtesy was abolished in 1925. No devise of land is possible except by custom in some towns. But as long as they do it before marriage, either of them can get the same effect by transferring land to fefis to uses. So in substance, bare trustees appointed to give effect to the wishes of the fefor. And the governing disposition is the fefor's last wishes or last will. Hence you have, properly speaking, a will for land and a testament for chattels. And we still have last will and testament, but even at the time, in the 15th century, the terminology is used inconsistently. Thinking of testaments, a widow or spinster, being a single woman, can of course make a testament. Can a wife do so? Canon law says yes, and that matters because testaments of chattels are a matter for court Christian. This is an extract from a 17th century edition of a work by William Lindwood, later Bishop of St. David's, on the canon law, writing about our time. And he says here, it's remarkable that in our days, husbands strive to hinder their wives from making a testament. But there's a snag, because the common law says that she has no chattels of her own. They've all vested in the husband. So it's one thing to recognize a testament, but what can she leave by it if she dies first? Court Christian will enforce legacies against executors and hold them to account. But that remedy isn't useful unless the executors can get in the estate. And that requires them to have recourse to the common law. So the common law has the whip hand. And the rule accepted by both laws, though reluctantly on the part of Lindwood, is that a wife can make a testament, but only if the husband consents to it. Though it's clear that this was actually done and wasn't just a matter of theory. What about getting married in the first place? Valid marriages are for court Christian to determine, and the minimum age is 12 for a girl, 14 for a boy. That's for a binding marriage. You can have a sort of non-binding one at an earlier age. And canon law requires a real consent from both parties, so that duress is a ground for divorce in the full sense, dissolving the union. What constitutes duress is not really defined. Family pressures are acceptable and don't suffice, but physical threats are enough, and even a threat from a father to make no provision for a daughter may do. I'm going to say now a bit about land law. I've mentioned it in connection with marriage. We'll say something more about it. Disputes about land are an important part of the business of the common bench. You don't actually sue for land in the King's Bench, except in some special cases. The principles of medieval land law are not especially difficult. And those of us who took an old-fashioned, historically based course in land law at university will find some of it familiar. But there are a variety of factors which make litigation about land complicated, which I won't go through now, but it is perhaps the most intricate part of the medieval law. Rather than discussing the technicalities, I want to have a glance at medieval conveyancing, called then, in fact, purchasing. Conveyancing nowadays looks at it from the point of view of the grantor. Purchasing looks at it from the point of view of the grantee. Purchaser is one who takes by voluntary act and not by inheritance. So a donee is a purchaser, although not a purchaser for value. The terms aren't the same thing. Upstairs in one of the strong rooms is a little volume of statutes compiled in the 14th century, something that a practicing lawyer would carry around in his pocket. My specs are there to give an idea of its size. I think Dunstan actually brings it out from time to time so that you can have a look at what the sort of thing a lawyer might have used. It's not much bigger than postcard size, is it, on the front? And in the 15th century, though it must have not been terribly useful as a statute book by then, somebody wrote in it a jingle or mnemonic telling you what to watch out for in conveyancing, what blots on the title there might be, to use more modern language. And on the left is the first of 2.5 pages of the verses, and on the right is the whole lot. The double strokes at the bottom of the first column, near the bottom of the first column, indicate the end of this page. It's been attributed, this jingle, to John Fortescue, a member of this inn in 1422, who later became Chief Justice of the King's Bench. There seems to be no evidence in support of the attribution, but he was one of ours, so we'll pretend we believe it. So looking at the jingle, first see that the land in the fourth line, first see that the land be clear in title of the seller. Well, that's true today in unregistered conveyancing. I'm just going to put on my specs. Then we've got see that he not in prison be and in good mind he be. If the seller's in prison, he'll be able to challenge the grant for duress. Sound mind is obvious. That it stand in no danger of any woman's dower. A widow's entitled to dowers, I've mentioned, out of all the lands held by a husband in fee simple during the marriage, even if he's disposed of them during the marriage. So be careful if you're dealing with a married man or the successor entitled to one. See whether the tenure be bond or free. That refers, are you buying leasehold or copyhold? Sorry, freehold or copyhold. Freehold is transferred by theftement, copyhold by transfer in the Lord's court. And see release of every feoffee. If you put the land in trust in the name of feoffees, you don't want to be dealing with the current occupier. You don't want to be solely dealing with him because you won't get legal title. A legal title is in the feoffees, so they've got to join in. Then we got at the bottom that the seller must be of age, 21 in the case of freehold, and the land not mortgage. Top right, look whether a tail thereof be fine. That's an entail. If you buy from a tenant entail, the heir entail will in due course recover the land from you by writ of formidon. And if it stand in statute bound, this is a reference to something called a statute merchant, which is a particularly stringent form of security for debt, introduced by Edward I under the statute of merchants. And so the arrangement itself was called a statute. You acknowledge a debt before the mayor of a specified town, and the details were enrolled. And then if you defaulted, the creditor could immediately have you arrested and imprisoned without judicial process. And from a conveyancer's point of view, the important point was that all the lands you held on the date of the acknowledgement were liable to execution to meet the debt, whether or not they've since been alienated. So a danger for purchasers. We've got what service belong there to. Feudal services owned to the feudal lord. You need to know what they are. And if they've been commuted for a quit rent, you need to know how much you're going to have to pay. There's a reference to wedded woman. Wedded woman can't transfer her own land during marriage. So this may simply be a warning that you need to check whether a woman you're dealing with is married. And then we have reference to warranty. This is a very common feature of charts of feftment. The transferor warrants the land to the transferee and his heirs and assigns. And it's similar to the present covenants for title, but it works differently. And the effect is that if a third party claims the land against the buyer can vouch the warrantor to warranty. The vouchee, who gave the warranty, takes over the defense of the claim. And if he loses, he has to provide the buyer with other land of equal value. The warrantor may die, but the burden of the warranty descends to the warrantor's heirs, as long as they've also got land descended from the warrantor, which they can use to meet the obligation. And then at the end, we find that if all goes well, 15 years purchase is a reasonable price to pay. So that's not really the land law, that's conveyancing. I will turn, partly because of its picturesqueness, I suppose, to law of crime. There's nothing to be proud of in the common law of crime. Here's an indictment. You can see why I chose it in an illustration. If we stand in 1422, a murder was, on the 15th of December, a murder was committed a few weeks ago in Chancery Lane, just around the corner, then called Chancellor's Lane. You probably have to think of it as a muddy track where a murderer could quite easily lie in wait, as this one is said to have done. I've put a blue line around Chancellor's Lane in the original. Strictly what this is a coroner's inquest on a dead body in which the jurors have named the murderer. And a verdict of that kind is treated as equivalent to indictment. Sometimes it's called an indictment. And it's sufficient to put the named person on trial. It's not a conviction itself, but it's the equivalent of an indictment. And this procedure was abolished in 1977. More narrowly speaking, an indictment is a presentment by a jury, later called a grand jury, that so-and-so has committed a crime, and then guilt is determined by a separate trial with a petty jury, a system which is still in full swing in the United States. As to the substance of crime, there are three kinds: treason, felonies, and trespasses. Treason comes in two strengths: high treason and petty treason. High treason is defined by the Treason Act 3052, still in force, and the various heads largely concern disloyalty to the Crown. And if convicted, the punishment is drawing, removal of the prisoner's entrails, and then hanging. Nowadays we talk about hang, drawn, and quarter, but quartering seems to come later. Petty treason was the killing of a master by a servant, of a husband by a wife, but not vice versa, or a prelate by a lesser clerk, and it involves the same idea of disloyalty. A man convicted of petty treason, I've never seen such a thing, but it did happen, is drawn and hanged in the same way as for high treason. A woman is burned. That's treason. Felony is homicide, rape, arson, robbery, burglary, and larceny or theft. And there's some statutory felonies. The punishment for all felonies is hanging, no discretion, except for larceny of less than 12 pence. What was 12 pence worth? Well, an agricultural labourer might be paid 3d a day, so the limit was a meaningful one. You didn't get hanged for a really trivial theft. And the offender also forfeited all his goods to the Crown, and his lands is cheated to the feudal lord. Looking for material for this, I bumped into a jury of matrons, which I mentioned earlier. And there is the entry from just about our time at a York jail delivery in 1423. So there we are. Bad luck, Beatrice. The jury of matrons was against you. So she was hanged. And then the third category, we've done treason, felony, trespasses. They're lesser offences such as assault. They're punished with fine or imprisonment. But in addition to all that, indictment, there's a completely different procedure called an appeal, which has nothing to do with taking a case to a higher court, but resembles a private prosecution for felony. So it can be initiated by a victim. A wife can appeal husband's killer, or failing her, the heir can do so. A woman can appeal a rapist, and the victim of larceny may appeal the thief. And one reason for an appeal in the case of larceny is that if the thief is convicted on indictment, the goods are forfeited to the Crown, and they include the very goods that have been stolen. So if the owner, it's only if the owner brings an appeal that he can get the goods back. But in addition to victims, there are another class of person who can appeal. A defendant to an indictment for felony can appeal an accomplice, but can only do so if he first confesses the felony. So if the appeal fails, the appellant, called in this context the approver, is hanged on his confession. If it succeeds, and the incentive then is that the accomplice is hanged, if there's a conviction by a jury, the approver, despite his confession, is let off hanging, though he has to abjure the realm. A trial of appeals is usually by a jury, and so the defendant in the appeal is either acquitted or hanged. But the defendant may instead offer battle against the appellant, unless the appellant is one of a category of accepted cases, such as a woman or someone over 60. The defendant can choose to offer battle, and this still happens, particularly in an appeal by an approver. The right to require trial by battle was abolished only in 1819, when some defendant shocked everybody by waging battle, waging meaning offering battle as opposed to fighting it. The court said, well, he was entitled to do so, but so very rapidly the law was changed. So unless, in a case of wager of battle, unless the appellant withdraws the appeal, one or other is killed in the battle, and justice of a kind is done. In Easter 1422, there is a grim little story. This is translated from contemporary law reports, except that I see that I've put it as Henry VI. It's Henry V, so just before his death. The exhausted appellee, the exhausted approver, the one who'd snitched on his opponent, could no longer fight, was dragged into court and told that he could either be hanged there and then, or he could go back and fight. And he said he couldn't, so he was hanged. There's another genial feature of 15th century criminal justice. A defendant to an indictment or an appeal had to plead, just in the same way as in a civil action, usually saying not guilty. And in fact, the criminal trial is a sort of archaic survival of oral pleading. But in addition to pleading, he had to put himself on the country, that is, agree to trial by jury. And there's a historical reason why you had to extort a consent from the defendant, unless he waged battle, as in an appeal. So if he refused to plead, or if he pleaded not guilty but refused to put himself on the country, he was put to his penance. So he's taken back to prison, stretched on the ground, and a sort of table thing was put on his front, and heavy weights were placed on him till it was more than he could bear. And while he lived, he was given on alternate days filthy water and small amounts of bread until he died. This, you can imagine, was not a very common procedure, but here is an example from 1426, though it doesn't describe the grisly details. This procedure was abolished in 1772, but it had been used earlier in the 18th century, and it was used in the witch trials in Salem at the end of the 17th century. there was a reason apart from pig-headedness for choosing this death. It wasn't a conviction. So the prisoner's chattels were not forfeited to the crown, and his family were left with something to live on. Now, this fairly savage regime is mitigated in practice, though the mitigation is a bit arbitrary. First, and I think nobody's really fathomed why this is so, there's a very high rate of acquittals. It's possible that the more easily accessible records sort of skew one's impression of this, but there seem to be a lot of acquittals, and it's not clear why. It may be that in some cases, at least, there was a feeling amongst jurors that it was enough to scare the living daylights out of a defendant. So it was a sort of not guilty, but don't do it again. Secondly, royal pardons are quite freely granted. There's a pardon, the practice of granting pardons for unintentional homicide. You can't say that unintentional homicide isn't homicide, because then the king would lose his chattels. But pardons are granted. And lastly, there's the famous benefit of clergy. And this derives from the claim of the church earlier in the Middle Ages that criminous clerks, clergy accused of crime, should be the business of the church courts, not the secular courts. And that was what lay at the root of the dispute between Henry II and Becket in the late 12th century. But a compromise had been worked out long before 1422, and by this time there's no longer any controversy. A clerk, somebody claiming to be a clerk, is tried anyway by the secular courts. If found guilty, he can be claimed in court by the bishop to whom he's delivered for punishment. And the punishment may be a real one, but it's not a hanging. How do you know that the prisoner is a clerk if he claims to be one at all? By this stage, the test is simply literacy, which means literacy in Latin. Nobody is just literate in English, even though a great many laymen can read. A verse is given to the prisoner to read, and if he does so, he's entitled to his clergy, though nobody really thinks that he was ordained. But men are still hanged because they can't read. Their record saying he was given the book, couldn't read it. And of course, women can't be in holy orders, so they can never claim clergy. So that's, on the substantive law, I've dealt with women in the law, land law, crime. There's obviously a mass of other material one could deploy, but we haven't time. Thank you very much indeed. Thank you.
As generously, but perhaps unwisely, offered to answer any of your questions. So if you have any burning issues about the law in 1422, preferably not cases that you're currently involved in, because he makes a charge for that, perhaps you'd like to pose them. Richard.
You didn't mention the Court of Exchequer.
No, well, the prioress had a claim in the Court of Exchequer. The Court of Exchequer is primarily concerned with, taxation is a slightly anachronistic term, but with getting in royal rights and calling royal officers, particularly sheriffs, to account. So it doesn't seem to do much in the way of ordinary civil business at this time. Later it does. And it also develops an equity side, which lasts until the first half of the 19th century. And it eventually becomes a common law court with more or less the same jurisdiction as the King's Bench and Common Bench, because the jurisdictional differences between the two benches are sort of dissolved by developments in the 16th and 17th centuries. So it's important later, but it's from the point of view of development of the law, it's not particularly significant here. Yes.
When you used the word attorney a few times,
Yeah.
did that have a special meaning, or was it just attorney in the general sense of someone who does something for another?
It meant both somebody who does the sort of solicitor type things that they do now, and somebody who's just appointed ad hoc to carry out some particular transaction. So if I talked about theftaments, this is a sort of formal handing over of land. Quite often that might be done by attorneys appointed for the purpose. But in the benches, you'd have professional attorneys acting for you, ferrying or seeing to the ferrying of writs between the bench and the sheriff, and sorting out pleas and doing all the sort of ministerial things that are associated with litigation.
You mentioned fines and imprisonment as the penalty for being caught in a criminal trespass. Who was that fine paid to, and who maintained the prisons? Were these official prisons? Were they fines paid to the king, or what?
Well, it's a bit difficult to know actually what the how trespassers were really dealt with. Fines would go to the king, and even the fine. The term fine is a bit. There are penalties that aren't fines. A fine, strictly speaking, is a compromise, a sort of deal to compound an offence, rather than just a sort of monetary penalty imposed from outside. As far as prisons are concerned, by and large, prison was not used as a penalty, or not very often, because it would have required the maintenance at public expense of a lot of prisons, and the king wasn't particularly keen on that. But it was, the various statutes were passed imposing particular prison terms for an offence. So there must have been prisons set up for that purpose, but mostly prisons were maintained simply to hang on to people until you could try them and hang them or release them.
This is probably an extremely obscure question about medieval conflict of laws, but I mean, to what extent, I mean, one imagines that in the case of canon law, there would be similarities between the law as it was exercised in this jurisdiction and in other jurisdictions. To what extent can one identify parallel developments in this in this secular jurisdiction and in other secular jurisdictions?
Yes, the canon law was the canon law of Europe. And there's a famous controversy at the end of the 19th century between Bishop Stubbs and Maitland, the great historian, about whether the courts here were really sort of independent of the authority of Rome and simply applying some sort of local custom. That's not a very good paraphrase, but or whether they saw themselves as applying the canon law of Europe, which was the theory that Maitland put forward, and generally he's thought to have had the better of the argument. In the for the secular courts, we had a very precocious development here of a centralized government and centralized legal system. And so law was developed out of the writ system, where you had these standardized writs. You know, you couldn't just sort of frame, as you can nowadays, whatever you wanted in a single writ. A writ of debt said what it said, and you got that if you were trying to claim a debt, you had to issue just a writ of debt, and it had to be in the standard form, and ditto trespass and so forth. So all of that law was developed centrally by what must have been a few hundred people in the central courts across the centuries. And it doesn't seem to owe anything much to what was going on the continent. The land law, because you've got originally you had a sort of proper feudal system, the land law may have been recognizable from one place to another, but the customary laws applied in other areas of litigation on the continent would, I think, though I'm very ignorant about this, would I think have borne very little relation to what was going on here. This is the common law really is an indigenous development. The lady there had a question. Do you have?
It might just because I'm short-sighted, but a couple of times in your talk, you pointed out words that were on the page and tried to locate the name, but I struggled to. I was just wondering how you learned how to read the script in these reports, right? So,
well, most reading old documents is mostly done by knowing what they say before you start reading them. So anything formulaic, you know that it's bound to start off in a particular way, and you can. But there are books of English scripts of different kinds, and if they put, you know, on the right-hand side a photograph of the document, on the left-hand side what the transcription, it's not actually all that difficult to make. To get the hang of how it works, and you can make yourself a little. If you're reading a text, you can make yourself a little alphabet, just copying out letters, putting the equivalents where you know what they are, and then the ones where you can't quite tell what they are reduced to a smaller and smaller number. It's and the court records, this sort of thing, are very carefully written, because they were quite pedantic about mistakes. You leave out a word or two and it might be fatal to in a piece of civil litigation. So it may look a bit weird, but it is actually very well done. What's a bit more difficult is that to save time, they put in a lot of abbreviations. You have to get the hang of those. But you know, if you ever wanted to do that, there are books available.
To what extent were the courts at this point actually bound by case law precedent? And as a matter of practicality, how were those records actually stored and accessed? And a third question I might ask as well is when one looks at these records, are there actually references to prior cases?
Sorry, I didn't quite catch that last bit.
Are there references to prior cases in these sorts of records?
The short answer is you do get lawyers citing particular cases, but only when everybody's expected to know what they are. So just as nowadays you chuck out a reference to Donoghue and Stevenson, you don't say you've got this great case and it's called Donoghue and Stevenson and take the judge to the relevant page. There is no system of binding precedent. They can't. It's very difficult for that to grow up where you've got no hierarchy of courts. The common bench decides, and that's it. If there's a decision, what I've perhaps scampered over rather was that this sort of thing, that handwriting, that is the court record. So there's a record of every case. I mean, some of them may have got lost, but the clerks write everything, keep a record of all the cases, most of which will be of no interest to practicing lawyers who aren't involved in them. They won't raise any new point of law. Whereas the reporters are sitting in court saying, that's interesting, and jotting it down. So what circulates in the profession is the law reporter's selection of what he thought was interesting. And you can't, I tried to describe it probably too briefly, the argument in court doesn't give rise to judgments. It's a matter of a lawyer will plead a plea, and then the other side will say, that's no good. And then there'll be an argument. And the court may just say, yes, of course, it's no good, say something else, don't be stupid. But mostly it will be a matter of the discussion going back and forth, and then the advocate will either insist on his plea if he thinks that the argument is going his way, or it won't, or he won't, he'll say something else. So you don't get much in the way of judgments. You certainly don't get long reasoned judgments. What you get is reports of argument in the law reports. And so the law is what there is a consensus about. And you'll see in the reports that somebody says, makes a proposition and the whole court was against it, or everybody agreed. And so there's this large area of propositions that nobody questions, and then perhaps a smaller area of propositions that might be the subject of argument. But not much in the way, you can't say, I've got a case here. Occasionally there are references to something in the manuscript reports that circulate, but it's not part of the staple of argument as it is nowadays.
I'm going to stop there because there's a glass of something and alcohol evaporates, quite quickly. We've had, haven't we, a fascinating hour or so. We've heard about some survivals, some really quite astounding survivals. How infuriating to have just missed the opportunity to bring an action in Replevin. We've heard about women. We've seen some medieval women in action on the pictures. We've heard about them as landowners and, of course, as inheritors. They quite regularly inherited businesses as well as property, and they got on with businesses that their husbands had been running. We've heard quite a lot about hangings, haven't we? Quite a lot of hangings, and again we've seen a picture of them. I mean, let nobody say legal history is dull, but actually, what you may not have appreciated is the enormous talent that Nick brought to this subject, which I think we appreciated as going on. It was a very difficult thing to do. I mean, we've all done a bit of legal history probably at some stage, and what you do when you do legal history is typically you take a subject or an area and you look at it across time, actually being able to do the snapshot from the knowledge of all those chapters of everything and picking where 1422 roughly intersects is a matter which requires enormous knowledge and enormous skill. And Nick has brought that very little period for us to life this evening, and we're enormously grateful to you. Thank you very much.
Thank you, Mark. Thank you.
The end of the not the formal part of the evening, but the 1422 anniversary events. It is not the end of the Black Book Society's role in the inn. You'll be glad to know we have a packed programme next year, including an event which will be part of the marking of the 400th anniversary of the consecration of the chapel. But the next event is on the 2nd of February. I've just realised that we had these flyers printed this afternoon. It says the 2nd of February 2022. It means, of course, the 2nd of February 2023. Dunstan Librarian will correct each one in manuscript. They're available outside if you want them. Now, what's going to happen then is that we shall have a talk by Dr. Ian Williams of University College London, and he's going to look at the following potentially quite interesting question, which actually bears a little on the final question that was asked. One of the things that people did after the rise of printing and after manuscripts started being replaced in quite a wide way by printed sources was they carried on collecting manuscript law books. And there's an interesting question as to why anybody should bother to do that. Why didn't they just throw them away and take over and use the printed books instead? So Dr. Williams is going to be looking at that on the 2nd of February. Bookings are already allegedly open, and that will be the next Black Books event. Well, with our continued thanks to Nick for entertaining us, and I expect some questions which are bursting from people's minds over the glass of something, we will now adjourn for that.
Thank you.
Good.